All right, are the parties ready on Nelda Rios? All right, court is calling 2022 CR 11792, State of Texas versus Nelda Rios. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense,
Albert Chidas for Ms. Rios.
are you Nelda Rios?
Yes, ma'am.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Nelda Rios who was placed on deferred adjudication in 2022 CR 11792 for the offense of possession of a controlled substance penalty group 1 less than 1 gram on April 19, 2023 for a period of 2 years? Is that you?
I do gotta say, I don't remember. I do have a head injury, but
All right, she doesn't remember that she was placed on deferred adjudication. Do you know when she had this head injury? Was it before or after she was
It
placed on
was-
probation?
It was before, Judge, and she did remember earlier when we were talking. It's something that I was talking with the state and with probation about. She does have some deficits. She goes to Center for Healthcare Services for treatment.
All right, so do y'all think she's competent?
She has been, this is the first, she says she doesn't remember being on probation. And we had actually talked about trying to help her because she was homeless. There's some issues that came up. She's on SSI for her head injury, but she lost her ID. And when that happened, she got evicted from housing. So we could work something out with Haven for Hope, get them to help her get her ID.
So
Temporary.
are you all looking to withdraw the motion and alternate main conditions?
Judge, we thought that it would be better to come and have the motion heard, but again, that's up to you.
I think it would be best probably to withdraw and alternate main conditions.
Your Honor, we were looking to maybe getting some evaluations done while she was in custody.
Ah. So what evaluations are we looking at?
The TAP
The mental
and
health.
mental health evaluation.
My only concern is I understand y'all want to do that in custody, but she's telling me she doesn't remember signing conditions or being on probation. She doesn't have a place to stay?
She was living under a bridge when she was arrested.
All right. So here's my question for you. One or two things can happen. You can remain in custody. While in custody, you will be evaluated. We can reset the motion to revoke, and you can be evaluated for the mental health caseload. Would you like to do that?
I already know that I'm not able of, that I cannot. Like, you have to tell me all over again, because I didn't understand it.
All right, let's do this. Why don't we see whether or not the mental health court will accept her? I know they only do pretrial diversions, but if nobody's going to object to it, I'm willing to do a motion for new trial. And we can start all over because I see I'm not the person who took this plea. So if you would check with mental health court to see if they'll accept her, because that may be the better placement for her, because I think she's going to need one-on-one care. So if you'll check with mental health court and let them know, and you'll have to let them know that she's currently on deferred adjudication, but I'm willing, if nobody objects, to hear a motion for new trial, grant the motion for new trial, because the key is to get her the mental health treatment. And this is a possession less than a gram case.
Yes, Judge.
Okay. So is everybody on board with that?
Yes, Judge.
Yes, Judge.
All right. So what I'm going to do is I'm going to reset you for 2 weeks. There may not be anything completed in 2 weeks' time because mental health court will have to interview you, but I just don't want to lose track of you in the system. Okay. Do you have any questions?
No.
All right, do you have any family?
I don't, I have that, sometimes I don't even have money to buy me a meal.
Okay,
I haven't been able to I have a bank account with Bank of America, but because I don't have an ID, because when I got arrested, I was in my apartment. And it's a long story, but I had gotten a better, criminal trespassing in my apartment, and that's why I got arrested for this case. I'm sorry for it.
oh no,
We came to court and went through all this process, but being out, I don't even have money to buy me something to eat or pay for a motel room because of everything I've lost. And I got arrested at the motel. And I know that I have had issues with mental health since I was 10 years old.
okay. All right, so we're gonna give you a 2-week reset. And that's just so I won't lose track of you. So now we have a plan. We're gonna try to get you in the mental health court. And probation, could you see about the mental health case evaluation while she's in custody, just in case that doesn't work out?
Yes, Sean.
All right, is there anything else?
No, Your Honor.
All right, Ms. Ferguson, I need a 2-week reset on Nell Rios, please. You're welcome. All right, so we're gonna put it down for August 29th.
Thank you, Judge.
All right, Deputy, before you take her back, Ms. Ferguson, can you give her a reset form so she'll remember?
Yes, ma'am.
Good morning. All right, so, oh, Mr. Morrison, come up, please. All right, so if you, so the last time we were here, there was some discovery on mental health issues,
So, Your Honor,
and then it was supposed to be a referral to mental health court.
that, I apologize, Your Honor, I didn't know about that update.
I go to the VA for mental health, and I have been since 2008. While I was active duty
Okay.
and after as well.
Yes, Your Honor, and we're trying to obtain that information so that we can present it for the state for possible mitigation.
All right. So is this going to be a referral to mental health court or no? Because the last time we were here, there was supposed to be a referral to mental health court. And this happened in July. So has that been done?
No, Your Honor. I need, if I can reapproach, Your Honor, and get better information, but I don't.
All right, so I can tell you all that was supposed to be done, the referral to mental health court. Now, if he's a veteran, if you all want to see if Veterans Treatments Court is willing to accept him, you can also see that. And if that's the case, then we'll have someone from Veterans Treatment Court come down now.
Okay, Your Honor, if I can just step back.
Sure. Okay,
Thank you, Your Honor.
no problem. All right, Robbins. All right, are you all ready to go on the record?
Yes, ma'am.
All right, the court is calling 2022 CR 11724, State of Texas versus Jordan Robbins. Can I have parties announced for the record for the state?
Brittany Mitchell for the state. Amy Owen for the defense.
All right. And the other two attorneys who are here?
Yes, Judge, Brandon Wong for Alexander Reed.
All right, so everybody, please do not whisper because the court reporter cannot hear. So,
Brandon Wong for Alexander Reed.
Yes, Your Honor. Rick Foster here for Dr. Javier Rodriguez.
all right. So before we get into the reason for the other two attorneys being present, I want to make sure that you have all the discovery from the state that the state has in its possession.
That the state has in its possession, I believe so, Your Honor. I do not know if that's what is in their possession is comprehensive of the order of the court of what was ordered to be turned over. I had not looked at that yet, since we do have a final discovery, I believe, setting, I think it's on the 24th.
It's the 24th.
So this was set for the motion to quash today, and we already have a discovery setting set on the 24th.
Okay. All right. So let's go over the motion then. And I have a first amended motion.
Yes, Judge, do you need a copy?
Oh, I have this. And did you file a motion as well, or is
I did
this?
not, Your Honor, found out about it yesterday, but we're subject to this motion because we're the doctor, one of the doctors that is being asked to produce records for Mr. Wong's client, Ms. Reed.
All right.
And Your Honor,
So defense,
Your Honor, so as the court's aware, we have argued, sort of argued this prior to the court. And we're not on a fishing expedition to for all of her medical records, but what we are interested in and looking for are medical records that occur between January 1st of 2022 up through January 31st of 2022.
all right, do y'all want to write this down, what she's asking for?
I can get it.
Okay,
Let Mr. Wong know. So there's American Health Imaging on January 6, 2022, January 18th with Dr. Nivra Beta, January 21st with Dr. Malhorta, and January 31st with North Central Baptist Hospital ER. And then we know that the outcry in this case is February 8th and 9th. And the reason we're asking for this, Your Honor, is that the mother of the complainant suffers from a frontal traumatic brain injury. We know that occurred in 2012. And those, because of, without revealing too much of our defensive strategy in this case, there's information contained within the case file of the civil discovery and within the court-ordered psychological evaluation by Dr. Richard Tice that gives us reason to believe that there could be exculpatory information contained within mother's medical records, mother's outcry witness in this case. And we believe that what is contained within those records could be exculpatory. We're asking for the court to do it. We're not asking for them to be turned over. We're asking if the court would do an in-camera review of these records to see if there's anything relevant to this case in terms of symptoms and diagnoses of what happened within the 30 days of outcry. And that's what we're requesting.
all right. And state,
Yes.
are you planning on calling this witness as an outcry witness or calling this witness at all?
She would be the outcry witness, Your Honor. And we had a hearing previously on this, and our position as to why we did not feel that these records were necessary was because she is just the outcry witness. She's not, the allegations themselves come from the child. The child said these allegations multiple times. And it's just very attenuated from how there could be any relevancy. It's kind of well, there might be something in there. And we don't know that there is. And it's the state's view that it's outside our duties to provide, which is why they chose to subpoena independently.
Well, the court's question, this brain injury, did it occur before or after the alleged outcry?
Before.
About 10 years before.
All right.
Judge, obviously, they're asking for my client's protected HIPAA information. It's just clearly a fishing expedition. The subpoena is defective on its face. They actually didn't even follow the procedure. They didn't serve my client. They never served my client with the actual subpoena for any of the records they're asking for. The subpoena is incorrect because it doesn't even list her name correctly, her birthday correctly. So again, no one can even provide the information they want because again, it's just defective on its face.
But obviously, you know,
Obviously, I know about it, but and
'Cause
that's
you're
why we're
here.
here. But the reality is, Your Honor, as the state said, none of this information is remotely relevant. They're just trying to simply fish. My client, again, she's one of many outcry witnesses that have heard the child's statement. She's not the victim. She's not saying this happened to her.
but this is the person that the state is calling as an outcry.
I get it, Judge. But again, she's not the only one. And then they're still able to have my client on the stand, ask her whatever she wants, whatever they want. You know, that is, we all know that is how it works. And so they're able to get whatever information. They're trying to link something that happened 10 years ago and saying, well, now she got some sort of mental handicap where she is now convincing her child. You know, that's their strategy. It's not even a secret. they're trying to say that she has influenced her child to say that these allegations have occurred to her. It's a stretch to say the least, Your Honor. And so again, it's just harassment on part of, they're just making my client spend countless dollars and time fighting this thing. She has nothing to do with it. All she did, she made a report and that's it. She's out of it. And so again, for them to now seek all of her records, now they're cutting it down. Originally it was her entire medical file, her entire medical records. And I understand they just want a couple visits here and there, but again, Your Honor, my client's still going to have to produce them. It's a hassle. There is nothing relevant that's going to come from this. And they're hearing it's possibly exculpatory. They don't know. There's nothing other than just their speculation. It's just pure speculation that they can come up here and say, we just want to harass this lady to get these records just so we might be able to strengthen our defense. And again, as the prosecution has said, it's just not relevant.
Okay. And do you have an argument?
Your Honor, we just merely support the patient, Dr. Rodriguez's patient, Ms. Reed. It's her record. She doesn't want to produce them. We don't want to produce them. And it sounds like from the summary that was given by defense counsel, they're not even asking for Dr. Rodriguez's records at this point. Is that correct? Even though it's okay, so we have a subpoena, but so we need protection from that subpoena. I can file a separate motion, or
Well,
we
I
can
mean-
agree on the record today that it's, or as the court determines, that subpoena
Well,
is
just one
withdrawn.
second, because I'd like to
Oh, yes,
cut to
yes,
the
Your Honor.
point.
Okay.
So this attorney, his patient, or his doctor,
Yes, Your Honor.
are there any records that you want from this doctor?
I don't believe so, Your Honor. However, since we don't have any, we don't know if it references, any type of diagnosis or treatment that's referred back to that. But these specifically, what I read are what we're requesting.
All right. So here's the thing. Number one, he's saying that the subpoena is improper on its face because it doesn't have the correct name, the correct date of birth. I think we all know who it is and who we're here for. If you want to make another trip down to the courthouse and they can correct the name and the date of birth, they can do that. But I can tell you what my ruling is going to be. What my ruling is going to be is yes, I need to see it in camera inspection, and I will make a determination of whether it's relevant or not. If I deem that it's not relevant from the in-camera inspection, then that will be the end of it. But I can't make a determination on whether or not a record is relevant or not until I see it. So just listen to everybody's argument. I've listened to your argument, but I need to see what it is. So she is telling me she has narrowed it down to this specific thing. And my understanding from both sides, or let me make it clear to everybody, that's the specific thing. We're not going outside of that specific thing. So counsel, if there is something that you feel that the attorney who's here today, that there's something that they have, let them know specifically what it is. And then if you all will present it to the court, not to the state, not to the defense, just present it to me, I will review it. And then I will make a determination whether it's relevant or not. And my understanding from defense, they're no longer asking for the entirety of the record, which I would think the entirety of the record would not be relevant. But the specific parts she's asking for, I'll review them and make a decision on that. So first question, are you going to want me to rule that on its face because it has the wrong date of birth, wrong name? And just
On its
say,
face, Judge, honestly, yes, Your Honor, they need to refile it.
all right, so
And then
this
I'll
is-
ask my client, once they've served a proper subpoena to provide said documents, and then, because I understand what your ruling is, but
Mhm.
obviously I can't agree to release her records when it's just not been properly done.
all right, so when will you have your subpoena ready?
Today.
All right, so she's gonna have her subpoena ready today. So while she's getting her subpoena ready, if y'all can get those records ready for the time frame, if you give them the time frame, it's not, I read very quickly. It's not gonna take me long to do it and to review everything.
And Your Honor, I think the other issue would be that in order for anybody to get the records, that the court would need to order Mr. Wong's client to sign a HIPAA release to the actual entities to be able to release the records to the court.
I'm not gonna order her to sign a HIPAA release,
Okay,
so.
so once we get the subpoena and then the court, we would direct the entity to send the records directly to the court.
Yes,
Okay,
and then if you all are able to get the records directly to make the process move quicker and bring them to me, and I will review them in camera. And as I said before, when I review things in camera, I really review them in camera. Defense doesn't see it, state doesn't see it, her client's not going to see it. I'll be the only person who's seeing it.
May I address?
Sure.
Your Honor, pursuant to HIPAA and the CFRs underneath that, we have, if it's a third-party subpoena, to be able to release the records, we need to be ordered to produce those records. And then there needs to be provisions that they're prohibited from using the records and disclosing them outside the litigation, and they're required to return the records upon the conclusion of the proceedings. And so
Here's
I
my
drafted,
thing.
may I pass something up to the? court?
Sure. But you may pass it,
Yeah.
but I will tell you, I don't believe in crossing bridges until they're built.
Yes.
So the first thing we need to do is, if you all will confer on the date she's speaking about,
Yes.
and then she can have her new subpoena, and you all just get the records prepared for the court. And if you all can have the records and bring them to me, because sometimes when things are mailed to the court, it goes to 6 different places. People don't read 187 4th floor with a suite number. So it goes to different places. And so nobody else will read it, just me. If y'all will bring it to me, and if you could put it in a sealed envelope that says judge only on it, nobody else will open it. The staff will not open it. It'll go specifically to me.
And can we go ahead and submit an agreed order on how those records are being tendered up to you, because you've directed us to do it?
Sure.
And
If you all
put it
can,
with the documents?
yes.
Okay, you okay with that?
Yes.
Okay.
All right. And then she'll get the subpoena. But I will tell you, our next court date in this court for discovery matters are August 24th. So if you all can have all those records to me before August 24th, that would be great. If not, I can read it on August 24th, but I just like to have leisure reading before that date.
Okay.
All right. So August 24th. Does anybody need anything else?
No, Your Honor.
No, you're not.
All right. And if there's not any objections from the defense, if you all want to appear by Zoom, you're more than welcome to appear by Zoom, as long as I have the records to review in camera. Is there going to be any objection?
No, ma'am.
All right. So if you all would like to appear by Zoom, just let the court know. And the court coordinator will give you the Zoom link.
That'll work. Thank you, Judge.
All right.
Good.
Thank you. All right. Who is the prosecutor on this case? Court is calling 2021 CR 0835, State of Texas versus Nicholas Cornelius. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
And Jackson Lindsay on behalf of Mr. Cornelius, Judge.
Are you Mr. Cornelius?
Yes.
Counsel, have you received all the discovery, and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Cornelius, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Did you understand you're charged with or at least the state is proceeding on the lesser included offense of robbery? That's a 2nd-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to accept your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge. I believe he's competent.
Do you believe he's currently, yes. Do you believe he was legally sane at the time of the offense? Mr. Cornelius, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of robbery, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense,
Yes, Judge.
state?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions? Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation and no contact with Jose Aguilar. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense of robbery, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State officer exhibit 1 and all attachments.
No objection.
All right. And state, have you been in contact with the complainant?
So we have been in contact with the complainant, Your Honor. There were other co-defendants in this case. One of them also did have the charge reduced to robbery and was given.
All right, thank you. Oh, you may be excused to continue to confer. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Caroline, we're ready. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Judge, we're waiving guilt.
All right, anything you wish to say on behalf of your client?
Just so the court is aware, Judge.
All right, so everyone, please whisper in the box. We're on the record. Yes.
Thank you, Judge. Briefly, my client had court in the Winston District Court back on May 31st of 2022. That day, he was arrested by the U.S. Marshals for a federal charge of being a person under indictment in possession of firearms.
Okay.
He spent 15 months in custody awaiting that charge. We worked out a deal in federal court for a plea bargain, accepting his ability to appeal that sentence because that particular statute is being challenged in the upper courts right now, 922 M. 18 USC 922 M. So because he was denied bond, he was in a position where he ultimately pled guilty because he did have the firearms. That explains why we took so long to come back to this court. He's here now, Judge. He's been offered deferred adjudication from the state. He's accepted it pursuant to the court's approval. As part of this federal judgment, after serving 15 months, he was placed on supervised release for 3 years, which I'm asking the court to run that concurrent with this federal case. And that in the event, unlikely event, I believe, he were to be picked up on a violation of probation in this court, that any time served in federal court awaiting disposition of that case be credited towards any time given in that case, in the event he's sentenced.
All right. Do you have any children?
Yes, ma'am.
What are their ages?
4, 3, 2, 1, 6 months.
And where are they? Who are they with?
Their mothers.
How many mothers?
3.
All right, that is not Black excellence. The fact that you're here is not Black excellence, unless that's the name of a building, but I'm assuming it's not. So you are not showing Black excellence to your ancestors or to your mother, your grandmother, or anyone. You understand?
Yes, ma'am.
So don't wear Black excellence if you're not showing it.
Yes, ma'am.
All right, are you employed?
Yes, ma'am.
What do you do?
Pack and moving, Apple moving service.
Okay. All right, this is what the court is going to do. Court will sentence you to 3 years deferred adjudication. There's to be no contact with Jose Aguilar. There's to be restitution, if any, to FedEx. Regular reporting. By Zoom or in person. Regular UAs. 200 hours of community service restitution. There's going to be parenting classes. Once he completes parenting classes, that will be deemed to be satisfied. Field visits. 1 time per month for 3 months. And probation if you all want to check with the federal government and see how their field visits are, you may not have to do any if they're doing them as well. So if you could check with them. There's to be no contact with Aubrey Reed, AUBREYREED, Charlie James Ray Perkins, Amari EMARI, LaFell LAFEL, Freeman FREEMAN. There's to be proof of employment within 30 days. No employment as a home health care provider or with minors. Probation, is there anything else he needs? Yes. All right, is there anything else you need from the court to have black excellence in your life?
I'm out.
Judge, maybe run this concurrent with this federal cause number. I can give you that cause number.
All right, concurrent with, what's the number?
SA:22-CR-294.
All right, the court will run it concurrent.
Thank you, Judge.
Going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am.
All right. Is there anything else you need from the court to be successful?
I'm out.
All right, we can go off the record. Here's the thing. From here on out, in this court, whatever you do in your life while you're on probation, you need to ask yourself two questions. One, is what I'm doing something that could potentially result in me being revoked and sentenced to prison for 20 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. Do you understand?
Yes, ma'am.
All right, good luck to you.